to not lose any time, I would like to hand over to our third presenter, which is Dr. Sven Korzilius, who actually had initially the idea for this cooperation. He contacted me during the pandemic, and we thought we should give it a try and have a look. And this is the outcome of our conversations. So Dr. Sven Korzilius holds a PhD degree in law from the University of the Saarland University in Germany. He works at the Heidelberg Center Latin America, and since 2018, he is a visiting scholar at the University of Chile. He is under the program of the German Academic Exchange Service, which is also our sponsor for our project, TGCL. Sven, I'm very, very much looking forward to your presentation and very excited.
Yeah, I use slides as well. Are they well divided, the slides? You see them well? Okay, so I talk a little bit about fundamental rights in Chile, and especially about the context of the protests. So this is the faculty where Rita and I work. And this was last year, 18th of October, a Friday afternoon. I wanted to go home from the faculty by bike, and suddenly the streets were crowded with people and I couldn't cycle home as I wanted. And I asked myself, why so many people in the street? What has happened? Was there an accident in the subway? Then when I came finally home, I turned my television on and I saw that the subway fare, the price, was increased, and that therefore people protested and destroyed a lot of subway stations during their protests. Here we see one of these subway stations. To see this as classical distinction between the more genuine causes and the more trigger, sometimes it's wrong, but here it was definitely right. This increase of the fare, of the price of the subway, obviously was only the last trigger for something much deeper, which we may analyze together. That was only the trigger. The subway price raise was well visible when we saw that in other regions of Chile, also the social protests grew. And instead of a nice Saturday night out, in the Saturday night, I experienced the first nightly lockdown or dusk to dawn curfew in my life. This was the first time that I saw that military occupies the city in the nights, and I can't go out in the night anymore. This was Saturday 19th. This year, nobody would have thought that a small invisible virus would cause us to live like this during months, because now we have this nightly lockdown as well, still in force for other reasons. But it feels different when it's for political reasons than if it's for health reasons. This is interesting, the psychological side of it. But the protests went on and grew between 18th and 25th of October. And then on 25th of October, we had this famous biggest protests with more than 1 million people. Here, this is Italy or Bagnano Square in the center of Santiago. Here, alias, is our faculty. So we can imagine that since mid-October, we could nearly not visit our faculty anymore because of the social protest. So here we have this big protest on 25th of October. And what is interesting is that the protesting people, after the protest or during the protest, got the idea to rename the square. Not name it anymore Italy Square, this part, or Bagnano Square, but Dignity Square. And I think here's only the first approach to my talk, human rights. Here you see the strong human rights impact in the discourse of the protesters. Yeah, dignity is the first human right mentioned in the Chilean and also in the German Constitution. So I think this idea to rename the place has strong impact to what we are talking about today. A second approximation to my talk could be to talk about human rights violations by police and armed forces during the protests. The most famous ones were eye violations caused by rubber bullets. Here we see how the people are sad about it, protest about it here, a concert on it. And here we see the National Institute of Human Rights, one of its members, reporting more than 300 cases of these eyes injuries. But on this punctual problem, maybe in a later encounter, we could come to these details. It's a very interesting theme, and we could talk more than 1 hour only about this, but this is not what I want to talk about today. Were the Chilean protests a surprise? For me, a relatively newcomer in Chile, definitely they were. But for sociologists and politologists who observed the Chilean situation during years, they definitely were not a surprise. There was something in the air. We may name precedents like, for example, the Penguin Revolution of the high school students in 2006. I think they were called penguins because of their school uniforms, but I did not discover exactly why they call this the Penguin Revolution. Maybe a Chilean colleague may answer this later. And when I arrived in May 2018, my first impression of the faculty was that it was closed because of a feminist occupation of several faculties. Here we see the gender dimension of the protests. This more punctual protest of feminists later on, I think, entered also in the larger protest of 2019. So yes, there were precedents, there was something in the air. This leads me to highlight some of the main issues of the protests. Why do Chileans go out to protest? It begins with social inequality in general, the high living costs. Yeah, Santiago, for example, is an expensive city, and the other cities in Chile are not much cheaper, and the high private indebtedness. To maintain this living standard in Santiago, a lot of families are indebted here. So frequently in critical discourse, the problems are linked to a neoliberal orientation of the actual constitution, expressed in the concept of subsidiary state. It's not so explicit, this idea of the subsidiary state, but if you want to look for a point, I think I'm back on the air. Here in this article 1, paragraph 3 of the Chilean Constitution, one of my Chilean colleagues, constitutionalists, see one of the articles where you can find this subsidiary principle, that the state retreats itself and that private initiative is fostered. A good example for this is the social security system, especially the retirement provisions, organized in private but obligatory so-called pension funds agencies. Here we see the protests against the pension funds agency, private pension funds, which you have to contribute. And here we see that it was no surprise and it's nothing new. Here we see Bachelet, which is our ex-president till 2018. Already under President Bachelet, the Chileans protested against this pension fund system. Here we see a newer protest against it, and I choose it because we here see very well the link. Punctually, they protest against this pension fund system, but they see this private pension funds as a symbol of neoliberalism. So here we see the intertwinedness. Dictatorship, which was the historical dictatorship of Pinochet, obviously, but the dictatorship continues in neoliberal economy, and this is why we need a new constitution. And one sub-aspect of this are these pension funds. So I think this is a very good symbol here to show the complexity of the situation in Chile today. Another dimension of the protests, obviously, is the ecological preoccupation. And in this context, water is a very good example. And here we again see the intertwinedness. People say we have a water crisis. A lot of small towns are lacking water because all the natural water resources are in the hands of big national, international, multinational companies. So here we again have this anti-neoliberalism combined with another aspect. here is the ecological and not so much the social aspect. This is why this water debates for me is very important. Another big issue are the rights of the native Chilean population. The biggest and best known group, but not the only one ethnically, are the Mapuche, again profoundly interconnected with the property aspect and the ecological process. We ask what property of the land do we want and what is the more ecological alternative? Maybe a common property in the hands of native people also ecologically could be more interesting. Here we have the big demonstration of the Women's Day, 8th of March 2020. I pull a little bit the chronological order because in the flags we see here, I want to see the multifacetedness of the protest. Here we see this famous Mapuche flag of the native population of Chile. Here by the color we see obviously a feminist flag, but also ecological and other themes became apparent in this protests. So obviously all of these problems have a profound constitutional involvement. Therefore there is no wonder that one of the cries of the protesters in October and November 2019 was that we need a new constitution and that we want the constituent assembly now. Yeah, this is what the people wanted, constitution assembly now, and they did it successfully. This is what is very nice in all this what happened, that peacefully government party members and opposition members came to talks mid-November, and they came to the agreement that yes, we have to put a new small chapter in the actual constitution. There was a constitutional amendment which said we need a plebiscite for the new constitution. This entered into force, interestingly, like a Christmas present of the actual government on 24th of December. This is the new Article 130 of the Chilean Constitution of the national plebiscite. It should take place in April, but because of COVID, it will take place now definitely on 25th of October. And I think this is quite beautiful symbolism also. Exactly 1 year after the biggest protest, we will have the plebiscite on the constitution now. Chileans may respond to two questions. Do you want a new constitution? And in opinion polls, I think more than 2/3 of the population want a new constitution. Then you can elect if you want a mixed commission, which would be between actual parliamentarians and free elected people from the people, or if you want a pure, newly elected assembly. This pure assembly without actual politicians inside also has a vast majority in opinion polls now. But why do we want a new constitution? Why do we need it? To do the social reforms, do we really need a new constitution? Before I go more deeper into these questions, I want to tell you about the symbolic importance of a new constitution. Why? What is the history of our actual Chilean constitution? Obviously, the military coup of '73. I think everybody knows these portraits, these two men. Salvador Allende died '73, and Augusto Pinochet took over the government in this military coup. So the actual Chilean constitution is of 1980 and is obviously a product of this military dictatorship. It allowed Pinochet to govern 8 years more, but it was the constitution which had, and this is interesting, a human rights catalog. Here I wonder if maybe this has to do with the Organization of American States as well. Professor Jesse James mentioned this influence of the Organization of African States into the human rights question. I did not investigate it, but maybe we may have suspect that it was international pressure which led to this human rights catalog. Obviously, during the dictatorship, this human rights catalog existed, but it was not enforced by the citizens. If you were tortured as a citizen, you did not have a lot of chances to get a due process to get indemnization or something like this. But then in 1990, after the dictatorship, this catalog of human rights in the Constitution of 1980 got a certain application. So it was not uninteresting that they had this catalog in the Constitution of 1980. So one of the aspects why we need a new constitution is this symbolic aspect, which is working up the past, working through the past, which in German we call Vergangenheitsbewältigung or Aufarbeitung. They come from psychology, these words, and here you see in Wikipedia in English that they don't even translate it. It's a little bit difficult to translate it. It's a struggle to overcome the past. And I think that we want a new constitution is not only because we need it to get the social reforms, but we need it as a symbolic break with this dictatorship past. This is one aspect why we need it. So a big issue in the actual debates obviously will be the basic rights. But to connect my talk a little bit better to James' talk, I want to tell you a little bit about the human rights in the actual constitution. Before I want to talk to you that the new constitution as well is not a new project. It's not a surprise. Bachelet, the ex-president, which went out of office in 2018, she promised it in 13 or in 15 when she began, but she only presented a project in the last days of her government. So there was a certain deception with Bachelet that her project for a new constitution only came in the last days of her government. But now let's talk about human rights in the actual constitution. I do not have the time to tell you all the catalog of human rights. If you are interested, you have to open the Chilean Constitution. You find it in English in Wikisource. It's the Article 19 of the actual Constitution, which has the catalog of fundamental rights. Some of the fundamental rights, the most important ones, a little bit like in the German constitutional model, we already find also in Article 1. People are born free, equal, and dignity. So dignity, personal freedom, and equality already symbolically in the first article of the Constitution. But now I want to talk to you, and very important to talk to you is also this Article 5, the second paragraph, which say that we also have to respect the human rights granted by international treaties ratified by Chile. So this opening clause to human rights, for example, in the American Charter of Human Rights, is very important. So maybe if our actual catalog of human rights nationally is not so complete, we can complete it because we have this opening clause for the international treaties and their human rights. The next part of my talk is about the human rights protection in Chile. Human rights protection in Chile is twofold. I have to simplify here a little bit. We have one human rights protection in the hands of the superior tribunals of justice, which have two instances, the courts of appeal and the Supreme Court. And here we have three important remedies. We have a protection action in Article 20, which I will explain later. We have the classical habeas corpus in Article 21, which I will not comment a lot of today. And we have a special protection action for your economic liberty, which I will comment quickly. And then we have, here I draw a certain line, maybe this would not be constitutional. Also for this tree, I question a little bit their true constitutional character. We have the contentious administrative cases, and here maybe the most important to protect certain human rights are the cases of expropriation. There is special proceedings in the cases of expropriation. And then we have the Constitutional Court. Here you can question certain legislative acts in an abstract control of norms, which in this human rights talk does not interest us so much. It's quite close to the German abstract control of norms, but we also have a concrete control of norms in which the parts of a juridical litigation may say that one of the norms, its application in the concrete case would be unconstitutional. So here we see this habeas corpus, which today I do not want to comment because it's the classical habeas corpus, nothing special. More interesting is this Article 20 of the Chilean Political Constitution, an action of protection against every arbitrary or illegal acts or omissions which leads to deprivation or disturbance or threat in the exercise of these human rights. And who commits this act is not only the state. This is interesting. This is also horizontal protection. You can do this remedy also against acts of private persons. And the first instance for this would be a court of appeal. So this constitutional protection action of the Article 20 is not a remedy stricto sensu, because it's no ordinary proceedings before. It's an autonomous action. It's decentralized control. It's informal and extremely summary. It's very fast and short. You only have 30 days after the act happened to get it to the tribunal. The decision has to be taken if it's against life or liberty into 2 days, or in 5 days in not so grave cases. Its character is inquisitorial. The judge has to look at that he gets proof as well, not only the part. It's vertical and horizontal, this I already mentioned, not only against the state, but may be directed against acts of individuals and citizens as well. It's not necessarily bilateral. The organ or the person who committed the act may enter as a part, but it has not to. It's guided a little bit by opportunity, procedural openness, and it's res judicata only formally, not materially. You cannot do the same remedy again in the same case, but yes, you can do an ordinary proceedings in the same case. This is what I call not res judicata materially. And you have an appeal to the Supreme Court in these cases. Then I come to this economic liberty protection. Economic liberty is protected in Article 19 of the Chilean Constitution. Here we have the general right to develop any economic activity. And in the second paragraph, this economic liberty is protected against state activity. So only in special cases, the Chilean state may do economic activity. And then there was created by a law a remedy if the state disturbs you in the exercise of your economic liberty. Here are two problems in practice and doctrine. The Supreme Court reduced the second paragraph, or reduced the application of this remedy to the second paragraph, and said you only can defend you against undue state activity. And we do not apply this remedy against limitations under the first paragraph. And the Supreme Court is reluctant to decide interim measures of protection. So the decisions often only declare a violation of this right, but do not give you interim remedies. Here we see the expropriation in Article 24 of the Political Constitution. I only want to call your attention to the mining rights as part of the property, exploitation concessions, and here this famous debate on the water concessions, that the rights, the concessions over water create a type of ownership over water. So here we can get into a conflict if the protests have success, and if in a new order we want to expropriate them, that their water concessions are property in a certain sense. Dealings on these expropriation cases, I do not want to communicate with you today. It's too special material for today. Then I concentrate a little bit on the Constitutional Court. He is only competent to control legislative acts. The abstract control of norms, I said I will not comment today. What is interesting for us is the concrete control of norms when there are pending proceedings. They may decide of the inapplicability of a legal provision of a norm whose application in proceedings before a court could result in violation of a constitution. And this is very interesting here, that we have two possible steps. First, the citizen who is part in the process can say, this norm may not apply because it violates my rights, inapplicability in my concrete case. And then in the second step, because it was inapplicable in a concrete case, the Constitutional Court may declare the unconstitutionality of this norm, whose inapplicability it found in the concrete case. This, I think, very interesting, because we do not do this like this in Germany, that we have this two-step proceedings here. One thing maybe you have seen during my talk till now, is there any protection by the Constitutional Court against acts of the judiciary? If you got a sentence of the High Court, can you go from this sentence of the High Court against it to the Constitutional Court? No, this is lacking in the actual Chilean system. We have no constitutional remedy against acts of the judiciary. Yeah. Finally, after this overview of the remedies, maybe to complete my image, I have to mention the National Institute of Human Rights. This has no court effects. It has investigative functions. It investigates the cases, and it may help you, kind of a lawyer, to get cases filed. Criminal cases against policemen who tortured you, for example, but also they may help you to file these constitutional remedies we mentioned before. Last not least, to complete the image, we have to mention the integration of Chile in the American Organization of States, and that you may appeal also to the Inter-American Court of Human Rights after having exhausted all the national remedies, like in most of our regional protection systems. To conclude this overview of basic rights protection under the actual Chilean Constitution, I would like to suggest maybe to the Constitution Assembly to debate it profoundly. The action of protection of Article 20 seems very problematic to me because of its decentralized, irregular, fast and preliminary character, and the lack of a true possibility of an incident control and a lacking of a true constitutional dimension of a lot of application. Horizontal cases between two citizens involving particulars on both sides, in my opinion, could be resolved in ordinary litigations of private law, and presuming that there exists interim measures. For me, they look a little bit more like extraordinary interim measures. I would include this in ordinary proceedings as interim measures. For cases directed against acts of the executive power, maybe the creation of an administrative judiciary would be interesting. This is not a new idea in Chile. In the ancient Constitution of 25, the idea already existed, but I think this could be retaken by the Constitutional Assembly, the creation of administrative courts. The actual doctrine in Chile says that this remedy, the Article 20 remedy, in fact, would be ordinary cases of administrative courts if we would have them. So there's no real constitutional remedy, but administrative justice in disguise, maybe. The second item to discuss is the creation of this lacking remedy to the Constitutional Court against acts of the judiciary. I think to complete human rights protection, we should have a constitutional court control of the judiciary. Only showing you the German example, our German constitutional complaints, individual constitutional complaints of 5,400 institutional complaints of the year 2018, more than 5,100 were against the judiciary. So the judiciary filters the cases, and if you are discontent with the last instance of the judiciary, then you have the possibility of a constitutional control. I think this is not so bad as a solution, that in the truth, a lot of constitutional cases would come from the judiciary. So maybe this remedy I would create in a new Chilean constitution. Before we turn on our attention to basic rights in substantial constitutional law in the context of the present reform debate, let me show you through the example of the reform of the pension system in Chile that in the actual situation, the relationship of social reform and constitution is defined by a profound problem in state organization law. In one word, the hyper-presidentialism of Chile. Actually, if the Congress wants to change the pensions regime from a private funded to a public pay-as-you-go system, but the president does not want to do this, the parliament only may do this by a constitutional reform because it has the initiative right to do a constitutional reform, but by the actual constitution, the Congress has not the initiative right to change a simple pension funds law, because this is exclusive initiative right of the president. The president has the exclusive initiative right to establish or modify norms on social security or that affected both of the private and public sectors. So if we would not have hyper-presidentialism, we could do a lot of things in ordinary law and not on the constitutional level, because we would have initiative rights in the Congress. This is one of the actual problems, why we push a lot of things on this constitutional level. Turning finally to human rights, in my opinion, an exhaustive catalog with detailed binding instructions for the future legislator would not only turn unnecessarily top-heavy the Chilean legal order as a whole, but maybe flowery promises, which in reality might not be fulfilled, could contribute to the discredit of a new constitution, which instead of being a well for the protests, could exacerbate them in the case of frustrated expectations. In the case of some candidates to enter the catalog of human rights, I wonder about the contributions to strengthen the level of protection. For example, what would we win if we give the bunch of consumers' rights the rank of a basic right? In Brazil, for example, in '88, and even more explicitly in Argentina in '94, consumers' rights entered into the constitution to force the legislator to codify them well in ordinary private law. But in Chile, this would not be necessary because consumers' rights already are well codified in the Consumers' Rights Code. As one Chilean colleague already wrote in 2014, to mention consumers in the constitution would not implicate a radical change in the interpretation of the actual Consumers' Code. So first point, necessity to push up every problem into a human rights question codified in the Constitution. My next problematic aspect is that the Constituent Assembly will not have a true budgetary responsibility. This can be very risky in the wide field of expensive social and cultural rights. One sector of the protesting groups is composed by students of higher education who often complete their studies highly indebted, because higher education, even if in state university, is paid. Therefore, there's a strong temptation to fix in the Constitution that higher education as a fundamental right must be free of charge. But in my opinion, it has to be carefully evaluated how to finance it instead. The same would be true maybe for the water debates, the recommunization of water. This would not be possible without indemnization of the big companies. Here we see the case of Berlin. Berlin bought its water back to recommunize it, but it paid a high price to the private companies who managed it privately. In more general terms, a new Congress after the new constitution might interpret human rights as being internally limited by a constitution immanent barrier of the so-called reserve of the possible. Yeah? So maybe we create big expectations, but our budget, state budget, is relatively small. Here's the problem, which in translating from German, we would call the reserve of the possible. A smaller but not less real problem is that the legislator simply might ignore a constitutional mandate to reform ordinary laws to achieve their conformity with basic rights. This is what happened in German history as well. In Germany in the 1950s, when we got our new constitution of 49, we had a clear mandate to make our family law in accordance with gender equality. Article 3 of the constitution of 49 said, men and women shall equal rights. But our family law and private law was not like this. We had a paternalistic family law. And then Article 117 of the Constitution said, the legislator has to reform family law until 53. And what did our legislator do? Nothing. Yeah. So sometimes the legislators do not do the necessary reforms, even if we put them in the Constitution. Turning especially attention to social basic rights, I would avoid the codification of rights which have only an objective dimension, which oblige the state but do lack a subjective dimension in the sense of actionability. For example, how would my claim against the state look like, for example, when I'm jobless and I want to get a job? Or how do I exactly claim against the state when I'm homeless? What would I ask the state? Buy me a house, build me a house. Yeah? The actionability of a lot of these social fundamental rights is highly questionable. The detailed codification, like in the Weimar Constitution, famous Weimar Constitution, here we see some of the examples of the well-codified human rights in the Weimar Constitution, not least because of their mere objective interpretation of social basic rights, could not prevent that after the Great Depression of '29, the social policies ended up in the Nazi catastrophe. First, we had workhouses instead of housing, and later on we even had killing forced labor in concentration camps during the Nazis. Yeah? Social policies ended in a catastrophe in the 1930s in Germany, and we had a wonderful catalogue of basic social rights. In the actual basic law in Germany, in contrast, the mothers and fathers of it showed great reluctance to codify special social rights, but as the example of decisions on income supplementary benefits show, dedicated judges of a constitutional court, elected only by the two parliamentary chambers. Yeah? In Germany, it's only parliament who elects our constitutional judges. During generations have done a great job to reach and maintain considerable social achievements, taking as a starting point nothing else than our few general clauses which we have, like human dignity as a human right, and the principle of the social state. The principle of the social state or welfare state in Article 20 is not even a human right, it's only a principle. But together, wrapped together with this Article 1, human dignity, we had much more concrete achievements today than we had with this detailed catalogue of fundamental rights of the Weimar Republic. Yeah? When we talk of income supplementary benefit, we nowadays, when we talk about a single person, jobless single person in Berlin, gets 400 euro for living, 430 euros for rent. So this would be more than 800 euros monthly as a social benefit developed out of Article 1, human dignity, and the principle of the welfare state. So we do not need too detailed social basic rights to do great achievements. As Germany history has dramatically shown, I simplified a little bit, an overcharged basic rights catalogue in the double sense of the number of rights we mentioned and the details of their aspects is neither a necessary nor a sufficient condition for successful social policies. Sometimes less may be more. Thank you.
Thank you. Wonderful. Thank you, Sven, for this very, very insightful presentation. And you already highlighted a little bit the differences between the German Constitution and the German way of protecting human rights, and also in Chile. And yeah, this is actually what interests me personally. Where are the differences between the different countries, and this is why we're here.